of the, oh, can you guys hear me okay? All right. Hey, all. Thanks. Thank you for being patient and waiting for us as we work through our technical difficulties. And thank you all for being here today. And just wanted to thank Clint Brown, who joins us today to talk a little bit about all of the new hearing requirements impacting homeowner associations across Texas. Clint, thanks for joining us. You want to introduce yourself to the group that hasn't met you yet?
Yes, sir. Absolutely, Mitch. And thank you for having me. And kind of to echo Mitch's apology, I want to apologize as well. The delay was in large part due to me, a bit of a calendaring mess up on my end. So thank you all again for joining us. And I apologize for us starting a few minutes late. So I'm with the law firm Roberts, Markel, Weinberg, Butler, Hailey. I'm an equity shareholder with the law firm. And I'll go ahead and just kind of advance to that slide. And I work out of our Austin office. So I'm board certified in residential real estate and community association law by the Texas Board of Legal Specialization. That just means I may know a little bit more about residential real estate and community law. But again, I'm here to chat about all the new 209 hearing requirements. And Mitch, would you like to say anything else before I get started?
Oh, no. I'm Mitch Krause, Chief Operating Officer at Goodwin & Company. And hey, just a couple quick housekeeping notes. If anyone has any questions for Clint, typically what we do on these is we'll go ahead and mute everybody. And then if you have any questions, just navigate to the chat, type in your questions, and I'll feed those over to Clint as we go. Sound good?
Perfect. Sounds good, Mitch.
You got it.
All right. So I'm going to give the old lawyer disclaimer for those of you that have seen me present with you before. You've heard this. The information presented is based on the law as it exists today, September 15th at approximately 11:13 a.m. So laws change, right? Cases come out, statutes are passed, as in this past 87th legislative session. And so, basically take it for what it's worth as of today. Additionally, the information I'm going to be discussing with you today is kind of given to you for educational purposes. It's not legal advice. And again, if you need legal advice on any of these issues, please be sure to work with your Goodwin team members and or your legal counsel. So with that, let's get right in. Okay, so overall, Texas legislative session came to a close. September 1st was the activation date for much of the laws that community associations are having to deal with now. And one, or actually a few of the big laws related to 209 hearings. So let's talk a little bit about the past for a minute. And I want to do a sidebar. This is for single family communities only and townhome communities that are bound by Chapter 209 of the Texas Property Code. So if you are a condominium regime or bound by Chapter 82, what we're discussing today is really not applicable to you. We are focusing in on 209 hearing requirements solely. So with that out of the way, let's talk about our 209 hearings. Prior to the legislative session, we really dealt with one type of 209 hearing. And that is when you sent the owner, or Goodwin sent the owner, what's called a Chapter 209 demand letter, and basically said, and apologize, I'm a big fan of Bob. Hey, Bob, if you don't mow your grass within 30 days of this letter or 15 days of this letter, we're going to fine you X. Oh, and by the way, Bob, you are entitled to a hearing before the board if you make that request within 30 days from the date of this letter. Something along those lines is what the letter says. So Bob can ask for a hearing, and if he does, he is provided with a date, time, and place of the hearing, and he gets to meet with the board to discuss why his grass isn't long, or why he doesn't want to mow it, or why he doesn't want to be fined, whatever the case may be for Bob. That was the only 209 hearing that we really had to deal with. Fast forward to today, 87th legislative session, Senate Bill 1588, all became law September 1st. And that one hearing has now morphed into 3 types of hearings. And we're going to get into each one of those 3 types, including the type that I just talked about, because they changed that one up on us as well. So first and foremost, let's get into our ACC membership. So ACC denials are now entitled to a hearing. There's some additional requirements I'm going to be discussing today as well regarding ACCs. But first and foremost, let's talk about what it means to be on the ACC and what restrictions are now in place. Currently, as of September 1st, you cannot serve on the ACC if you are a current board member, a current board member's spouse, or a person residing in a current board member's household. So those 3 items, if you meet any of those 3, you cannot be on the ACC. That's the general rule of thumb.
And we got some questions. What is an ACC? That's
Architectural Control Committee.
And associations may name it different things. It's the Architectural Review Board. There's all kinds of different ways to name it, but it's the folks in homeowners association who are responsible for approving architectural applications.
Absolutely. No, to Mitch's point, they can be called ACCs, ARCs, DRCs, multitude of names for them, but it's basically the committee tasked with approving or disapproving improvements within your community association. Most associations have them. Maybe the architectural reviewer, maybe another term of art you're familiar with. So that is your ACC. So you cannot serve on the ACC if, and then those 3 items that I just went through. Now, here are the exceptions. It does not apply if your community is made up of 40 or less lots. So that's exception number 1. So if your community has 40 or less lots on it, you're good to go. Exception number 2, it does not apply during, and I'm going to use a broad stroke term, and then I'll get into these exceptions in more detail, where your community is still under developer control, basically. And to get more specific, it's where the declarant appoints a majority of members of the ACC, and that's not or, it should be of the ACC, somehow controls the ACC, or has the authority to veto or modify a decision of the ACC. So if you are still in development control period and you've got the developer appointing a majority, or all of the ACC has some sort of control over the ACC, or can veto or modify a decision of the ACC, then this does not apply to you. This ACC member requirement does not apply to you, which is good news for developer controlled communities. It makes it a lot easier to manage the improvement application process. Now, here is the other exception. I'm going to mention it, but I'm going to provide a caution afterwards. If you are currently, as of today, you are a current board member on your board and you are a current ACC member on the ACC. So you're wearing 2 hats, right? There is a way to interpret the law, and I think it's a valid argument. I'm not suggesting otherwise, that you technically don't have to remove that ACC hat until your board term is up. So if you're wearing 2 hats, you're on the board and you've got a year left on your board term, could you technically, making this argument under the statute, still be on the ACC? And I think the answer is yes, you've got an argument to that effect. If that's something you want to utilize, be sure to get with your counsel, work with your Goodwin team member, your manager. But again, here's the caution. That is not the intent of the statute. The statute really is intended to separate the ACC and board. So even though you may be able to wait a year to get it done, don't let that be your only reason for not separating the 2. So again, just food for thought. That is an exception you may be able to rely upon in addition to these 2. Yes, sir.
Question, and just to clarify, what's applicable to condos here and throughout this presentation? Not applicable.
Nothing. There is nothing. Yeah, it is all 209 focused. Yes, sir.
So apologize for those of you who joined and were looking for all of the hearing requirements for condo boards. Hey, you don't have to worry about this. So it's and
And I mean, what I can do though, Mitch, I can discuss this kind of general broad stroke theory
Yeah.
as we go through that would be applicable to condos as well.
Sounds good.
Okay, perfect. So those of you on the condo, if you want to hang on, I will be discussing hearing process generally as well for ACC applications.
Yeah.
So this is the rule. Now let's get into the law. Okay. I'm again going to pick on Bob. Bob makes an application for a 30-foot pergola in his backyard. He's always wanted that 30-foot pergola. He loves how high it is, and it's going to make it look great with lighting and all that other fun stuff. So Bob fills out his ACC application, and he submits it to the ACC. That's the name. That's the term of art we're going to use, ACC. And the ACC reviews it and denies it. So used to be you could just send a denial via email and say, hey, Bob, this is denied. And technically, unless your governing documents provided otherwise, you really didn't have to give a reason for the denial. I'm not suggesting the ACC didn't give a reason, but legally, unless your governing document said you did, you didn't have to give a reason. You could just say, hey, Bob, this thing's ugly. It's denied. And you've more or less complied with your governing documents and state law. Now you have to get into more detail. So you've got to give a reasonable basis for the denial. So let's assume our restrictions for backyard structures no taller than let's just do feet, no taller than 15 feet. So the basis for denial for a 30-foot structure, and let's assume, just for discussion purposes, all other aspects of the pergola are approvable except for the height of 30 feet. So you would send a notice to Bob, hey, Bob, your pergola is denied because it is 30 feet and the maximum height for pergolas is 15 feet pursuant to Article 3, Section 5 of our Architectural Control Committee guidelines. That's the first aspect of it. Now, another way to do this, and I'm not suggesting you do it on the pergola example, but you can do what's called a conditional approval. Hey, Bob, your pergola is approved if, number one, you lower the height of the pergola from 30 feet to 15 feet. So you approved Bob's structure, his pergola, subject to a condition precedent. So he's got to meet that condition if he wants to construct the pergola. And the condition is reduce the height shown in your drawings from 30 to 15. Those are two ways to get it done. Step 2, you have a right to request a hearing within 30 days of the date of the notice. Third thing you've got to require, you have a right to request an appeal from the ACC denial or conditioned approval directly to the board. So if Bob activates the appeal, it goes to the board. It is completely out of the ACC's hands. So that is what the notices now require for ARC denials or ACC denials. So your ACC, get with your counsel, or Goodwin may already have a good form that complies with the law in place, because you're going to have a form, kind of a baseline document that you can input information on when you do those denials or conditional approvals.
Glenn, a couple questions that came in, and this is one that we've been getting a bunch. Speaking to the previous slide, is we've got 45 homes. We don't have enough volunteers. What do I do?
Yeah, so let's go back to kind of these requirements here, Mitch. I think it's a really good argument, a good point. Y'all are literally 5 away from meeting, being exempt. Law says what it says. What do we do? So for the time being, right, you're probably still wearing both hats, which again, as I mentioned earlier, there's a legal argument you can make that you can still wear both hats. And I feel comfortable supporting that decision if you were my community, because You have no volunteers. So what do you do? Option number one is, obviously canvas as much as you can to try to get interest. And y'all may have already tried to do that in years past and it's failed utterly. Option number two is to maybe work with Goodwin. Mitch, do y'all offer that as a service, maybe as an additional service?
Yeah, it's a good question. It's one that we're actually looking at because I've got a number of board members that are saying, hey, we don't want to get off the board to do this. We don't have time to do it. Will you do it? And so a couple things. One, in the interim, the answer is, we can get by. So one of the things that we've been doing is operating under the assumption that if manager receives an application, we've got the town square system that we operate on. And in that town square system, there's the architectural review application. That application inside of town square allows for a homeowner to complete an application. Manager can review it and then kind of make a decision from there. I think that the caveat that we work off of, at least in the interim, is that whoever's approving, and it doesn't have to be a member of the community, whoever's approving that architectural request can seek guidance from anyone, right? I mean, the statute doesn't bar, insight or questions or advice. And so long as the board isn't putting a stamp of approval on it, we can go ahead and move it. The idea is, and the intention of the statute is to have someone else doing it. And so we can certainly work with your community if you're in a bind on how to manage that process and support that without having the board necessarily being the approver on that application. I think where we run into issues is where we need to, talk through some very specific considerations with something that might be unique or different, in addition to a home on a lot or a installation of a pool or something, from that perspective, just having a conversation around whether something should be approved or not. But the idea is we'll do what we can to help you get by. And then we're in the process of looking at addressing those needs and see if there's an appetite for us to make an investment in someone who will handle just approving applications on behalf of those former committee members who are also on their board. So more to come on that. It is something that we're in the process of doing. It's just trying to understand what the economics of that look like. And in the interim, working with your manager to help you through that process is just fine.
Perfect.
Mm-hmm.
Well, it sounds like Goodwin's willing to help y'all in the interim.
Mm-hmm.
And I think Mitch makes a really good point on the board giving thoughts, right? And I think that's okay. I think the board can still give a little bit of input to the ACC or to Goodwin, whatever the case may be, just as long as you are not decision-making, right? You've got to stay away from decision-making on an application so that you don't violate the law. But in terms of giving thoughts, giving some advice, what you're seeing, the applicability of maybe guidelines or what the aesthetics of the community are, all of that's helpful. I'm completely okay with that as well. So Goodwin could be an option. Another option, again, is a professional company, a third-party company that comes in unrelated to the association. The benefit for Goodwin doing it is Goodwin already knows your documents backwards and forwards. Why? Because they're your management company. The professional company would have to get up to snuff, get up to speed on that. And I've seen some companies that do this that charge a pretty hefty fee. Again, you can pass that on to the owner as a application fee requirement. More than likely, your governing documents will allow you to do something like that. But again, you've got to think about the fees associated with it. So
it's there's not a lot of folks in that space, and there's not a very big appetite for boards who make the decision to charge their homeowners for an application review. And so it's kind of one of those things where we'll try to figure out how to support that when we don't necessarily want to spend the money on it. So it's certainly worth a conversation. If anybody has any questions, you're kind of stuck in a rut around that. Be happy to have a conversation around that and figure out how to make that work for you. Couple questions I think are great ones for the topic that we're on. Does the board still have the power to deny an approved ACC request that violates the CCRs or will cost the community? So I guess the board, I guess the question comes in, what's the role of the board when they're hearing, when they're in this hearing? So whatever decision they make, is it binding? Can they reverse the decision of the ACC? How does that work, Clint?
Yeah. So part one of the question is ACC approves something the board doesn't like. Can the board overturn that ACC approval? And unfortunately, I got to give you the old lawyer answer. It depends.
Mhm.
It depends on your governing documents. If your governing documents give the board that type of authority, then my answer would be yes. I think the board absolutely has the authority to overturn a decision of the ACC based on the governing documents. And I do not believe state law would conflict with that authority. But again, it's got to be in the governing documents. Now, part two, to Mitch's comment, ACC denies or conditionally approves. It gets brought up to the board through the appeal process, which is now statutory. What can the board do? It can basically do anything it wants to, right? It can reverse the decision of the ACC. It can affirm the decision of the ACC, or it can reverse and basically change it all up on what's approved and what's not. It can do its own conditional approval. It may even be able to grant a variance, assuming there is variance authority in the governing documents. So yeah, once it gets up to the board, y'all do have some authority based on this statute. And that's the whole purpose of the appeal process, right? Is to get something in front of another governing body to take a look at it and make sure the ACC, the other body, did it right. Okay, so Bob, back to our 30-foot pergola, and let's say we do a denial, outright deny. Hey, not in line. Our ACC only allows for 15-foot gazebos. And they send the notice that I just went through, and Bob requests the hearing within 30 days. So he timely makes his request, so that activates a new time frame. You must hold the hearing within 30 days from the request. So you've got a 30-day period for Bob to request a hearing, and then once he does, a new 30-day period goes over to the board, and the board has 30 days to hold the hearing. And you also have to provide the date, time, and place at least 10 days before the hearing. So you get the hearing date, you've got to meet a 10-day requirement as well. So again, lots of timing involved. Postponements, either party can grab the one freebie postponement, and it's whoever grabs first, and it's a 10-day postponement. So if the hearing's scheduled for X date, Bob can say, I can't make that, I need to postpone, and Bob gets a 10-day postponement. The other way to do a postponement is by agreement. I like agreements a lot more on hearings. So, Bob makes his 30-day hearing request, and let's say the board doesn't meet for another 45 days, which is obviously outside of the statutory guidance and even the 10-day postponement period, right? Because 30 plus 10 equals 40. So you're 45 days. If you just email Bob and say, hey, Bob, our next board meeting is on this date. Are you okay holding off until then? Most of the time, the owner is going to be okay with it, unless it's a pool. I tend to find that pool applications, they want that approval yesterday. They're moving on this, and it's the pool contractor pushing really hard. Other larger improvements, I find that as well. But if you can do a postponement by agreement, do it. If not, just know the statutory guidance here on timing requirements. Okay, so we send the denial notice. Bob requests the hearing. We give Bob a notice, 10-day notice of the date, time, and place. And can they be virtual? Yes, they can. Can they be in person? Yes, they can. Just be aware of all the COVID-19 restrictions in place, or actually not restrictions. Currently, they are guidance, but just be aware of the guidance and recommendations in place. So Bob shows up. Next question is, does the entire board have to be present? And this kind of goes to the third point. It must be an open session of a board member of a board meeting pursuant to 209.0051H7 of the Texas Property Code. So it must occur. The denial of an ACC application must occur during the open session of a board meeting. And you're scratching your head on this. I think a lot of people do, but traditionally 209 hearings should be held in executive session, right? I mean, it's private. Nobody wants to air their dirty laundry and get into the ifs and whens and whys and the anger from the owner. So why do we have to do it in open session? So the law provides for open session. But then here is another unique aspect to 209.0051. In my opinion, it conflicts a little bit. You can consider it in executive session, deed restriction violation history stuff. Is this a deed restriction violation? Well, it will be if Bob builds a 30-foot gazebo, right? Or pergola, excuse me, in Bob's backyard. But what about the other exception for holding things in executive session? You can hold things in executive session by agreement of the parties. So if Bob and the association agree to hold the 209 hearing in executive session, guess what? It can be held in executive session. It could be held outside of a board meeting completely if all parties agree to it. Why? Because, you know, statutorily, you've got what you've got to do. Can you make sidebar agreements with the aggrieved party? Absolutely. So again, how to get around this open hearing session requirement, get with your counsel. Potentially you could incorporate something in your denial letter that says something to the tune of this, you know, will be held either in executive session or outside of a meeting, unless you in writing say you want to have this during open session, something along those lines. But some wording your attorney may be able to come up with. Again, get counsel from them, get with your Goodwin team members. But if you don't have anything like that in place, you have to comply with 209.0051H7, which means this darn 209 hearing is held in open session. So kind of a curveball on that, but the law says what it says.
A couple questions to clarify. So getting a couple questions about just overriding. So one, if the documents don't speak to denial or that the board can override the ACC's decision, what we're talking about here specifically, and I'll just make this clear. One is if the documents don't give the board authority, and we take that to mean that they don't have that authority, or is that just kind of gray area in the documents?
Yeah, so this is a tough one, Mitch. So let's go back to it. ACC approves the construction of a 30-foot pergola.
Mhm.
The board finds out about it.
Mhm.
Bob has not constructed the thing yet.
Mhm.
And there is no authority in the governing documents for you to overturn an approval of the ACC. So ACC approves this. The board has no authority in the governing documents to overturn an approval of the ACC. Does the decision stand? If Bob had already constructed it or was in the middle of constructing it, I would say, look, board, you guys are in a tough spot here, because although it is a technical violation of the declaration, you know, the ACC approved it, and a court is going to be less likely to require Bob to tear the thing down due to a kind of a equitable argument. It's called economic waste. The courts are rarely going to require somebody to tear something down due to economic waste, and pergolas are not cheap. Now, if Bob has not constructed the pergola yet, I think you could probably send a very sternly worded demand letter to the ACC and to Bob and say, look, this clearly is a violation of our governing documents. We will be enforcing this deed restriction violation because it's 30 feet when the governing documents say it must be 15 feet. And ACC, you messed up. that's one way to try to put a stop to it. Now you've got to keep in mind, maybe your documents have variance authority by the ACC. So the ACC may try to say, hey, we're going to grant a variance. So the first thing you should really do in that type of issue is pick up the phone, send a fairly cordial email to the ACC and say, hey guys, y'all probably didn't see this, but you dropped the ball on this one. It's 15 feet and y'all approved a 30-foot pergola. Please get with this owner, stop them. They haven't started constructing yet. Have them stop immediately. And fingers crossed, y'all have got a good relationship with your ACC and you can get it fixed. And again, there's multiple options on this, but those are just a few ways to try to combat that ACC approval.
Yeah, so I've got a lot of board members that are kind of super anxious about this. They've had to kind of welcome in neighbors for the first time to approve these applications, and they kind of want to be involved a little bit just to make sure that the right decisions are made. So what I suggest to you is if you're on just straight paper applications that we're kind of passing on to the committee after we review them, make sure that, we'll make sure that our manager can copy, whoever's interested in being involved or advised of what's going on, specifically even the questionable ones, and certainly just continue to serve as an advisor to that committee if you want to offer some support there. Some of you have years of experience just going through that process of applying, voting on things and approving things or rejecting things that a newcomer would have difficulty with. The other piece, if you're on either Smart Webs or on Town Square and you're taking advantage of that architectural tool, shameless plug, that we make available, it is very easy for you as a board member to have admin rights and kind of see the flow of the applications and offer insight. So always want you guys to have access to everything that you need to in Town Square, and certainly those applications give you an opportunity to kind of stay engaged with what's going on and provide some quality control. But again, the idea is that once well trained, the committee will make sound decisions, and in the event that someone appeals it, it'll come to the board, and then the board will make that decision whether to uphold that decision or to reverse it. And so that's the idea here, and it certainly makes a lot of sense. Sometimes difficult, especially when we're struggling to get volunteers, but shouldn't really change much. There was always a bit of an escalation anyway to the board from homeowners who wanted to know, hey, why did this get rejected? And I think this just makes it easier for people to communicate and say, hey, at least let me hear from somebody, and be able to have an audience that might be a little more objective to what that initial verdict was.
Absolutely, Mitch. And look, I'm going to echo Mitch here. Do not decision make, right? Discuss, offer advice, maybe a little counsel. Do not decision make. And again, some boards, y'all may not like to hear this, but I have seen this being done with a lot of my clients. Basically, a board member who is the ACC guru, he, she, or they resigns from the board, right? And takes on that ACC role. At least for the newcomers, right, that are coming on. And look, I get it. Y'all worked hard campaigning, getting voter support. It's a difficult decision, but that could be an option as well. And a vacancy on the board gets created. And, maybe the vacancy stays vacant for a little bit to give you 6 months to, get everybody in line. And then maybe you hop back on the board, you get appointed back to the board. There's some different options. Again, get with your Goodwin team members, your manager, and your counsel, maybe to discuss that option more if it's something you want to look at. Anything else, Mitch?
No, just another question. Do ACC committee members have term lengths? ACC committees largely, unless documents specify otherwise, those are usually appointed positions. So,
yep.
So no elections for ACC. I don't think I've ever come across anything like that.
Well, and here's the funny thing on Mitch's point. So the board has no control over the ACC's decisions, right? And there has to be this separation and yet the board can appoint and remove ACC members. Bit of a head scratcher, but it is what it is.
Yep.
I think y'all can connect the dots on that, right? All right, so that is it I've got kind of for the ACC denial process. Before we move on, do we have any other questions on that before we get into the other types of 209 hearings?
That had a question. If the ACC approval contains the subject to the DCR guidelines, including measurement requirements disclaimer, does this allow the board to maintain that the pergola was built outside of the approval?
Yeah, so if you're, absolutely. So if the approval was not complied with, right? So it's a conditional approval, and it's like, you're approved to build your pergola as long as, and then you've got all the specs in there, and they don't meet the spec sheet, right? Absolutely, that's a violation, and the board can enforce. Anything else, sir?
Last question was, please clarify what you mean by executive session. Executive session is those sessions that happen. There's a certain number of things that you can discuss in executive session, which is the board not having an audience present. It's not an open meeting, but gives the board the privacy to have a conversation around typically, what is it, Clint? 15
deed restriction violations, collection accounts, employee issues, attorney-client privileged communications, right? So I'm your attorney, I issue an opinion that can be discussed during exec. And then the last one, and this is the one I was kind of hanging my hat on, by agreement of the parties, right? So if the person doing the appeal and the board agree to have it during exec, then you don't have to have it in open.
Yeah.
Anything else before we move on, Mitch?
No, that's it.
Okay. All right. So next one, 209.006 letters. This is called the Chapter 209 letter, the infamous Chapter 209 letter. You've got to send a special type of letter, and by you, I mean Goodwin, has to send a special type of letter at least 30 days prior to ... And then here's the laundry list. Sending to the attorney for the attorney to initiate litigation demand letters on deed restriction violations. So it's not collection. Collection is another section. Suspending privileges. So you can't use the pool anymore, Bob, for a violation or failure to pay. So Bob fails to pay his assessment, and you want to suspend Bob's right to use the pool this summer. You have to send him a 209.006 demand letter. And you also have to comply with another section of the code. I won't get into it though. Levying a charge for property damage. So, Bob has a little too much fun, runs into your perimeter fence. You've got to send this type of letter before levying a charge for that damage. Levying fines. So for a violation of the restrictions, you can levy fines as long as your governing documents allow it, but you have to send this letter. And then finally, reporting Bob to a credit reporting service. You've got to send this type of letter. Those are the things. Here's what the letter has to have in it. It's got to be in writing. It's got to be sent certified mail, and it's got to ... describe the violation or property damage or other issue that is the basis for the suspension, action, charge, or fine, and state any amount due the association from the owner. And then tell the owner that they're entitled to a reasonable period to cure the violation and avoid the fine or suspension unless the violation is uncurable or poses a threat to public health or safety, or the owner was already given notice within a 6-month period. So Bob doesn't mow his grass in month 1. You don't have to send another one of these letters in month 5. In month 7, you do, right? Because the 6-month period clock restarts. So you've got to send a new 209 letter every 7th month. All right, so you send your letter, owner requests a hearing within 30 days from the violation, not denial, excuse me. You've got to hold your hearing within 30 days from the request. So Bob gets his violation letter for building a 30-foot gazebo. Bob requests his hearing within 30 days. New clock, board has to hold the hearing within 30 days. Postponement periods, exactly the same for ACC denials. Any party can request 10-day postponement, or you can do a postponement by agreement. All right, so the owner requests the hearing. Not later than 10 days prior to the hearing, the association must deliver a packet to the owner. This is an evidence packet containing the association's evidence it will introduce at the hearing. Photos, documents, communications, etc. Basically, what do you need to do to prove up you have a valid violation? If we're dealing with this pergola, you've got the spec sheet that you include, and then you've got pictures of the pergola showing that it's 30 feet. Maybe you've got a couple communications in there. You've got the original ACC application. That's your evidence. Now, if you do not provide the evidence within that period, the owner is entitled to an automatic 15-day postponement of the hearing. No ifs, ands, or buts about it. Owner can waive that, obviously, but they're entitled to a 15-day postponement. So now we've got this evidence packet. What about the hearing? All right, so again, 10 days, document photographs and communications, automatic postponement. We're at the hearing stage. The association has to present their case in chief first. Why we win, why this is a violation. It's kind of sounding like a mini trial or a mini hearing. So association presents its case first, its case in chief, and then the owner gets his, her, or their opportunity to present their case in chief, why they think they are right. Either party gets to record this hearing. I forgot to mention this, that applies to ACC denial hearings as well. They get to record those. Bob gets to record this one. And then if the hearing is in front of a committee, so it's not a board hearing, it's a committee hearing, they get the chance to appeal this up to the board. So here's our hearing packet. The gazebo or the pergola example we're dealing with, I think you can work with your manager and figure out a good way to proceed through this hearing. If you are dealing with a much more complicated hearing process with a multitude of violations and issues, you likely need to get your counsel involved on this hearing. Why? Number one, it gets recorded. And because it gets recorded, it can be used against the association in litigation. So if you misstep, if you say something wrong, if you present something wrong, it can kill your lawsuit if you have to proceed against this owner for something egregious. So again, the more complex or complicated the violation, the more likely you need your counsel present to help guide you through the hearing so that you don't have any missteps. It really has turned into a bit of a just a mini trial. Okay, so
Clint, I've heard others say that don't present an evidentiary packet, right? Somebody can come before the board, say, state their case. Board says, hey, this is what we're working off of, in this case, a violation letter that has a picture of overgrown weeds, right? And says, here, this is what we have. This is what we're working with. You received a copy of it in the mail. It's got multiple pictures on it. There's really nothing to talk about here. Where do we go with that?
Yeah, so the simple stuff, you do exactly like that, Mitch. So hey, your hearing's on this date, this time, this place. Here's the letter we already sent you. They show up to the hearing. You say, look, here it is. You've got it. There's really nothing to discuss unless you've got something new to present. They don't. They just want to talk. You say, well, thank you so much, Bob, for your time. We'll let you know. Or thank you so much for your time. Board, I'd like to make a motion to deny this appeal or deny his request to have this overturned. Vote on it. It's done. Or you just stand on the violation.
And that's really it, right? So, it's how you keep a meeting that could go an hour, keep it to 5 minutes and make it very cut and dry is, thank you for bringing this to our attention. And we appreciate the opportunity to hear you. Here's what we're going off of. We're going to stand with where we're at. We're going to stand firm on this, make the motion, deny it, and we're good to go, right? You don't have to sit there and get into a back and forth. And in many cases, I would encourage you guys not to. somebody's very passionate about something, it's not going to, you never know where those things go, right? We don't want to get, we don't want to bring more conflict into this, but, just state your case very calmly and make your decision. This doesn't have to be a hour-long rebuttal.
Yep, absolutely. Absolutely, Mitch. And again, they're entitled to present their case according to the statute, but for those simple matters, it really is like that. And you limit it to 2 minutes and you're done. You place that cap at the front end, you go through it, and then you move on to your next 209 hearing if you've got another one.
And the other question, inevitably is, does that mean I have to bring Clint or my attorney to every one of these hearings? The answer is no, right? I mean, it's probably worth a conversation between management, the board, and, your attorney if there's something that's really complex, especially something that, homeowner made a large addition, and now you've got just a bunch of different factors to work through. Have a conversation around it, and legal counsel can offer you guidance on how to present it back to the homeowner. But ultimately, once you make a decision, you make a decision. And
Yep.
if it's like it's never changed. If the homeowner wants to take it to court, they take it to court. But the reality is that you are the ultimate say in this, and somebody would have to challenge you through the, through the court system in order to reverse that. One other point of clarification is, just because that may be a little misleading, owner may appeal decision to board if hearing in front of a committee. To be clear, these are typically going through the board first. The committee wouldn't hear it, or there wouldn't be a committee for violation purposes. So
we have 209 hearing committees sometimes, Mitch.
Mhm.
So it's kind of a committee the board sets up because they don't want to deal with 209 hearings for deed restriction violations.
Yeah. Rare.
So that's the only time that is applicable. Otherwise, it's the board hearing these things. And you're right, Mitch. Most of my communities, the vast majority, it goes to the board. They don't have a subcommittee.
No. We're just
you tend to see that with the big
on the board.
The big 4,000 plus communities where you have maybe 15 209 hearings every month.
Yeah.
That's when you kind of think about doing a committee.
Yeah.
Absolutely. And again, to Mitch's point, the easy ones, the easy violations that they're requesting hearings on, you do not need counsel present. In my opinion, it's a waste of association resources.
Mm-hmm.
It's the more complex and complicated ones that you really need to have an honest discussion between, as Mitch mentioned, the board, Goodwin, and your legal counsel. All right, so that was hearing type number 2. This is the third type of hearing, and it deals with credit reporting. So the association cannot credit report if the amounts due are subject to a pending dispute between the owner and association. So what kind of dispute are we talking about? It's when Bob, the owner, requests the hearing under 209.006.
Mm-hmm.
Bob requests that hearing. We got to press pause on that credit reporting. Now, the association can report if, and here are the if requirements. At least 30 days before the reporting, the association sends by certified mail, hand delivery, email, or other agreeable means a detailed report of all amounts due and owing at no charge. And then the owner has been given an opportunity to enter into a payment plan. So as long as you meet those 2 requirements and Bob, the owner, doesn't request the hearing under 209.006, which again is another type of letter you've got to send before you credit report, then you can credit report. But if they've activated that hearing requirement, you've got to press pause on the reporting. And Goodwin, Mitch, you and I spoke about this. I think Goodwin's got everything well in hand on all the processes internally.
Yeah, exactly right. If we've got a formal process by which a homeowner will dispute a charge. And then from that standpoint, we can make the board aware. We'll put them on a kind of a hold status, and allow the board to weigh in on whether proceed or not. But that is a process that we'll communicate in our letters and make that very clear, and a mechanism for that homeowner to dispute that formally. I think there's some confusion from the audience around ACC and violations. They're not one and the same in terms of Nothing really changes from that standpoint. If you, somebody asked if you can go back to the last slide, Clint.
Oh, yeah.
Yeah, if you are, so in terms of somebody appeals for the purpose of that violation, I mean, as we mentioned earlier, it'll go back to the board. It's not going to go to the ACC. ACC is just ACC's ACC architectural requests, and they're going to either approve or deny something. And then everything else goes to the board in most cases, except in the exception of larger communities that might have a 209 committee, as you mentioned.
Yep. Yeah. And look, it really is easy to kind of confuse it because they are somewhat related. So let's go through kind of a timeline here. Let's use the old Bob's pergola as our example. So Bob builds, he makes an application for a 30-foot pergola. The ACC denies the application. Bob appeals that denial to the board. The board affirms the denial. Sorry, Bob, 30-foot only. Bob, hey, can't tell me what to do on my land. Bob builds a 30-foot pergola. The board then sends, through Goodwin, a 209 demand letter. Bob requests a hearing again. This time, that hearing goes directly to the board. The ACC is not involved at all. So the ACC has done their job as it relates to denying the pergola. So they are yanked out of the process, and now it is just the board. That's kind of it in a nutshell. So Bob, arguably in that example, can have up to two hearings, one for the ACC denial and then one for the deed restriction violation letter that Bob got from Goodwin.
Interesting question. If a association interprets their documents that they don't have the ability to have an ACC, or expressly prohibits an ACC, or references that the board will be the one to approve or deny, at this point, that's pretty much null and void. You have to have someone other than the board by statute, and statute trumps the documents.
Yeah, I think that's a fair statement, Mitch. I can come up with a few exceptions potentially in my head, but overall, I feel like that's a fair statement. Basically, the statute controls. But again, that's kind of one of those questions you need to get with your manager and more than likely legal counsel to do a look at your declaration.
Question came through. What if a homeowner never actually goes through the application process? What's the association's remedy for getting somebody to undo what they did?
Yeah, so you've got two options, right? And this is the first question I always ask when the board calls me with the manager and they want to sue, cease and desist letter, temporary injunction, temporary restraining order, all that good stuff. First question I ask is, okay, they didn't submit an ACC application. Not okay, right? You've got to submit an application. If they had submitted an application, would you have approved it, ACC? And if the answer is yes, I would have approved it. It's not a cease and desist type situation. Mm-hmm. It's a situation where you get with the owner, you send the letters, you follow the process, and if they still won't fill it out, maybe the ACC fills it out for them and says, look, Bob, just sign this darn thing. We're trying to follow our ACC guidebook. Now, if, however, it's a clear violation, there is no way it is ever going to be approved. You've got two options. You can require them to make an ACC application and then have the ACC deny it. If you're thinking about maybe giving a variance, if he, she, or they have a good reason, if there is no way ever a variance will ever be granted for this thing, 30-foot gazebo or pergola can be sent throughout the community, then you just treat it like a violation. It's a deed restriction violation. Again, utilize your Goodwin team members, send that 209 letter, get it over to council to send our demand letters. But there is no rush at this point because the improvement is done, right? There's no need to rush down to the courthouse. It's already there. So, yeah.
Yep. I think there's some confusion as well on, just to be clear. So correct me if I'm wrong here, Clint, nothing really changes, whether it's an ACC, a violation the clock still runs on a violation, and you can still issue a fine, right? So it doesn't mean that you have to wait around for someone to, request a hearing before you can impose that fine. The Everything just continues to go the same route.
Yeah.
The homeowner just has the ability to seek, as they really always have when it comes to violations,
Yep.
to seek support of the board. What we're talking about here, specific to credit reporting, which is a practice that we use in helping really on the assessment side to mitigate past due assessments. It's just another tool that we use to just alert a homeowner of a past due assessment. But none of this really changes that. So it's not like we're giving people more time or that we're giving them an extra 30 days or anything else. If you fine, you fine. And if that homeowner has a problem with that, they'll come back and say, please, please give me an opportunity to be heard, and then we'll address it. And if ultimately the board says, hey, you don't have any standing here, it's a violation, is a violation, is a violation, then we move forward as is, right? There's nothing too complex about this from that standpoint. It's not like we're giving anybody more time or delaying the process.
Yeah. So the only time period you've got to worry about, and this is not new law, as Mitch points out, you've got to give them a reasonable period to fix the problem and avoid the fine. That reasonable period is not 30 days.
Right.
Many times it is because it coincides with the hearing requirement of 30 days. So it's just easier to do it that way. But I've got plenty of associations whose reasonable period is 15 days.
Yeah. Yeah. We run by default kind of on a 15-day period. Most of our communities have our compliance driver going out twice a month. And so every couple of weeks they're out there, and then they'll escalate it if it hasn't been addressed. But there is no, make that very clear, there is no definition of what's reasonable. So if it's, cutting your grass because the weeds are to your knee, knee length, 2 weeks to get somebody out there to push a mower is reasonable, right? Most of the things are reasonable. And if they're not, really that's all we want is for a homeowner to come to us and say, hey, here are the circumstances. I get that I messed up or that I haven't fixed this, but I've got somebody coming out here in the next 3 weeks. Can you give me a little time to get that addressed? Hey, perfect. It's why we have a group of folks who take those calls every day, and they just note it in the system and let the driver know, let the board know, hey, we're working on it. This person just asked for a few, little grace period here to get this addressed, especially in today's world where it's hard to just get, contractors out, or, there's so much fight for resources to get something corrected that it's reasonable. Give the person time to correct the issue, and and then we'll run the clock again, right? And we'll escalate that fine if they didn't live up to their end of the bargain. But that's how it works in, I don't know, 90% of communities, is that as long as somebody's communicating, they get the letter in the mail and they say, hey, just give me a few more minutes, or a few more days to get this done. Okay, what's a valid due date, and let's get this going.
Absolutely. Yeah. It's all about reasonableness.
Yeah.
2 weeks is fine for mowing grass. 2 weeks is not okay for having Bob remove his pergola, right? I mean, you need to give Bob a little bit more time to get the contractor out to fix the issue.
Does the board have the right to require that the offending 30-foot pergola be removed or rebuilt to the CCR specifications? You talked a little bit about the economic waste factor, but somebody builds a pergola and it's 50 feet long instead of 30 feet long. Can you say, hey, this needs to be cut back 20 feet?
Absolutely. Yeah, no, we've got to take that position. I mean, you as a board are kind of either you've got the power or the duty to enforce the restrictions, right? So that's one of your job functions through the use of Goodwin and your council. So yeah, if there's a clear violation, they didn't build it to spec, ACC spec, then yeah, you've got an obligation to pursue that as much as you can pursue. And look, a court may not order them to tear it down, but the court is probably going to find against them on that if it's a fairly straightforward violation. And you may be able to get the court to tear it down. I've seen it happen. I dealt with one about 4 years ago, and the court ordered that this metal roof be removed and be replaced with proper roofing materials. So I've seen it happen.
Clint, I think that does it for questions. Appreciate the engagement today. Everybody had some great questions to offer. After today's call, I will be sending out copy the recording, and I'll copy Clint in the message out, and we'll share the slides if that's okay. Clint, you good with
Yeah.
the slides? So
Yes,
we'll get
sir.
that out to
Of
everybody,
course.
and then if you have any questions, I'll copy Clint on. If you want to connect with Clint, I'm sure he'd be more than happy. He's got the 5-minute rule. Is that right?
5-minute rule. That's right.
Offer
Just got to remember, you get what you paid for, right, Mitch?
Right. That's right. So, no, great guy to talk to. And Clint, appreciate your time, man. Thank you so much for your time today, and look forward to reconnecting with everybody on this call soon. We'll have more great webinars in short order. Thank you all.
Sounds great. Thank you, Mitch.
Have a good one.
You too. Bye, everybody.